Good day, everyone. I'm Richard Fink, a lawyer who specializes in workers' compensation law. Today is the Workers' Compensation Workers' Legal Side podcast with Richard and Paul. Paul Taylor.
Hello, Richard. Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal from the Law Society of Ontario with a specialization in workers' compensation law and human rights law. If you want to reach out to Richard or myself, you can contact us through the links below. This week's topic is appeals for injured workers. Specifically, we're just going to go a quick run through of appeals at the WSIB level, then going to the Workplace Safety Insurance Appeals Tribunal, which is separate of the board, and then possibly, unfortunately, if you have to do a judicial review and hire a lawyer like Richard to deal with the judicial review.
So I just wanted to also mention that Pamela Hughes Ford is on the podcast today. She's the legal assistant at Fink and Bornstein, and day to day is dealing with the appeals at the board and tribunal. So she'll be able to give us some administrative background as necessary. Thanks. So go ahead, Paul.
Yeah, no problem. So generally, I'll just go over a quick summary of the appeal. So when a case manager makes a decision, unfortunately, this is one of my big bones of contention is appeal time limits. When you look at it from a logical perspective, they'll go, that makes sense. You got to have time limits for appeals, court of appeal, and everybody there is. My argument is that there was never time limits up until 1998, January 1st. That was almost 100 years. And the reason why I believe is because if a worker is denied their legitimate entitlement to workers' compensation, it actually hurts society. It hurts the family, the friends, the worker, and taxpayers, because then they have to then provide for them. So that's my little rant about the imposing of time limits. So at any rate, when a case manager makes a decision, there's two important things. One is if they're just making a general decision, you have 6 months, I believe it is, to appeal at the WSIB. And then, thanks, Pam, she's correcting me, or confirming. And then the other one is the important one, which is return to work, the one that I hate, and that I believe is 30 days, right, Pam?
That's correct. So it's return to work or retraining because they call
Right.
it two different things. Yeah.
And
Yeah, I
it's the
know.
second shortest time limit in all of the province.
Yeah.
Yeah.
And I know when I was going through it, it was two completely separate things, but now it seems to be they put it together. I don't know. That's another topic again. Again, coming back to return to work because in my opinion, it's a very big bone of contention. So once you've done that, you'll prepare your uh, intent to object. It's very, very important. You put that in there, and I've heard some reps say just write all issues. Simple. As long as you meet that time limit, you're good. Then you can go looking for a rep or a union rep or a lawyer, paralegal, or whoever, and then they'll go through the process. Once you've met that time limit, you're good. Thankfully, you can take as much time that is needed to get it right and get your appeal in. Once that's done, you file your appeal readiness form with all your evidence and paperwork. Then the WSIB appeals should schedule a hearing quickly, but I'm sure they're backed up
So
and it will
Pam,
take time.
how backed up are they at the tribunal?
The tribunal or the Appeals Services Division.
Well, it's both, I guess.
So
Yeah,
Appeals Services Division, which is where the appeal readiness form goes to,
yeah,
right now, they are trying to prioritize any decisions regarding loss of earnings benefits if the worker is currently not receiving benefits. So that usually, from when the case manager gets the appeal readiness form to it being sent over, you're looking at a couple of months. If it's something like a Nell appeal and you're sending it in, you're looking longer. So you're looking 4 to 6 months until you get a reply. And then it's usually done by written submissions because they deny an oral hearing.
How long in total would you say until you actually get an answer?
Like an actual ARO decision after you
Yes.
send it in, you're looking at anywhere from 6 months to about 10 months.
yeah, that's about standard. The
And the
other,
tribunal?
The tribunal right now, you're looking at from the point that you send in a notice of appeal form with the ARO decision, you're looking at 12 to 18 months until you get a hearing.
Yeah. And then a decision is about 6 to 8 months,
Yeah, they
depending
tell
on
you
the
it's
backlog.
supposed, yeah, the WSIAT decision protocol is 120 days after the date of the hearing, but more and more frequently in the end of 2025 and the beginning of this year, we've gotten letters saying it's going to take longer. We just don't know how much longer. So we've had 4 cases off the top of my head that that's happened with.
Yeah, like I like the law on that. The law actually says that the tribunal must make a decision within, I think it's 120 days or whatever, or let you know. So in other words, okay, 120 days comes up. Dear Pam, sorry, it's going to take us longer. Like I literally looked at that section of law and said, what's the point? Like
Yeah.
it was almost like they were gonna put it in and say, you gotta make it, and if you don't, then this. And I mean it's just a pet peeve I have in dealing with the boards, tribunals, and even the courts where and I mean I'm not blaming the individual decision maker. What I'm talking about is the system. Obviously, it's because they don't have enough of them and they don't have enough resources. But it puts a big toll on the individual waiting. Like as you said in Ontario, most workers, if their benefits have been denied, they get nothing. Alberta, on the other hand, they're allowed to apply for and get interim benefits. And surprisingly, that section of law, it was put in by the NDP, and when the Conservatives came in, they left it in. I can presume it's because, well, they would just deny the requests anyways, but that's another thing. But that's another important point. While you're waiting for the appeal, don't ever assume, oh, I'm going to get it tomorrow. They're going to change it right away. Unfortunately, it's going to take a long time, and you need to prepare for the reality, an alternative source of income. Ontario works, even disability, short term, long term disability benefits. Oftentimes, I've heard reps incorrectly say, you can't do that, it's insurance. No, it isn't. As long as you let them know, my claim was denied by WSIB, now you have a right to those benefits. If the appeal is overturned, your obligation now is to notify both and say, look ahead, and then the WSIB will send them that money or whatever, and it's all legal and proper. The most important thing is protecting the worker, that they have some source of income. And this is something that injured workers have a big, legitimately a concern about because the government, the judges, the tribunal, the board, they're all getting their checks every week. This individual or individuals aren't getting anything. There's no thing in the landlord tenant if you're paying rent for them to go, oh, we understand you're waiting for a board. They want to get paid just like the grocery store. And that's one of the big failures in the compensation system, as you said, Pam, where the times for them making the decisions, again, I want to reiterate the importance in saying I'm not blaming the decision makers and saying they're lazy, they're slow. No, I'm saying clearly there isn't enough of them to get these decisions out quicker. It's
When
the same
we when
problem.
we when we speak to the union person next week, we should ask them what is the board and the union doing about this type of delay.
Yeah, I think, Richard, and not to get too far off topic, but it is part of the appeals issue. And one big, huge issue I have is that it bothers me more with the board and the tribunal, the compensation system, because it's the only system that has a so-called surplus where they've given back, what is it, 6, 8, $10 billion to employers. So clearly they have enough funds to fund the program so that there isn't hardly any delays on that side. On the rep side, it will take time because you may have to say, okay, well, Paul, you have to go to an IME, you have to book the appointment, it has to be done. Then they have to take time to prepare the report. This could take months, you know what I mean? Because getting in to see them, then them writing up a report, it doesn't take 5 minutes. So getting back to that point, the worker needs to make sure they have some alternative source of income somehow or to survive, basically, as they say. One mistake most injured workers make, and I know they do it, is living on credit, hoping the decision comes back positively. Living on hope on that decision coming that way is a big mistake. That's one I learned as well as many will, is don't anticipate getting a positive decision. As they say, plan for the worst, hope for the best.
Yeah, I
So,
just, sorry, can I just point something
no,
else out? So
yeah,
also the other thing that I just want to point out to everybody is that even if you get a successful decision from an ARO at the Appeals Services Division or WSIAT, there's a couple of problems with that. People don't realize they get the decision, they're like, oh, great, I'm going to get benefits because I was granted something. And then there's 2 things that I just want to point out. One, The decision itself has to go back to the WSIB. It then has to be assigned to an implementation case manager who the majority of the time then will write to the injured worker and ask for information that could take you a while to get, like your taxes, or provide me with a list of every doctor you've seen since your date of injury. There's all this information. Or on the flip side, you could get a decision that says, yes, we're granting initial entitlement, but the benefits stemming from it is up to the case manager operation level. And then the case manager could turn around and say, oh, well, I looked at it. And yes, although you get initial entitlement, we're not actually going to pay you benefits because you weren't showing that you were trying to job search at the time, let's say, or you weren't in active medical treatment. So people may get a decision because this happens to us and they'll call us and go, oh, great, I got initial entitlement. But then 3 months after we send in all this information and the implementation case manager looks at it, they say, oh, well, even though you got the entitlement, we're not going to pay you any money. And then our clients are going, well, wait, I don't understand. And then you have to go back through the appeals process again and start back at the case manager level to go back up through each stage of appeal.
Yeah, I find that sometimes, sadly, it's like a never-ending battle that,
Yep.
to me, once you win your case, you should win and you're done. But it isn't, sadly. It's an ongoing, like, just like you said, I had won my appeal, got, everything, and then the case manager says, well, you weren't doing a self-directed job search. I later find out years later that's illegal. Any job search has to be done and sponsored by the board for them to be making it as a requirement. Now, the board more than likely will say, oh, well, that policy or that decision works against us. So what we'll do is we'll just rewrite the policy and do it this way. I would also argue on job search, it's nice to turn around and say to somebody, you should be job searching, but how the hell can you job search when you don't even have enough money for transit, let alone, going anywhere, doing anything, or actively looking for work, right? And then to know what your restrictions are, because as we know, the board, in my opinion, sets them, and that's not right, but that's another topic again. So, like it goes to that point where, yeah, if you're able to do some form of work, then yeah, look for it, do it. But there is points where the workers, and in talking to their doctor, they're saying, no, you shouldn't be working, and this is where you get this idiotic, moronic back and forth fighting. And it's like some reps say it's a tennis match or back and forth. I did see a case, I read a case, and I just went, yes! And it was in Alberta, where the appeals commission had overturned the decision for the worker. It was clear, benefits, entitlement, everything. There was no ambiguity, nothing. And the board literally went, yeah, no, we're not going to do that. What? Yeah, we're not going to. So what do you do? And in this case, the worker then hired a lawyer like Richard, and they went to court. And where I went, yes, is I actually read the decision from the judge. It's funny because Alberta's very conservative like Ontario, so I was surprised. But the judge said, yeah, you may not want to follow the appeals commission's decision, but if you don't follow mine, I will hold you in contempt. So it was that sense of justice for injured workers to say, you're not outside society, you are a human being and you do have rights. It was nice to see that. And that's something where if the board chooses not to implement a decision, it's one thing if they say, well, it's just initial entitlement and we think you can work or whatever, that's a new issue. But if it's something where they're just saying, no, we're not going to do that, I think there are alternative avenues instead of going back and fighting the appeals, because some have said they've gone back and forth like a tennis game. And I'm like, no, in that situation, you need to break it. Either in many, like in your case, where you can escalate through the management of the board or call the president's office is what I used to do. If that doesn't work, then you can take a legal avenue and try and do an enforcement step process of the tribe, because the tribunal, in my opinion, is like a court. It's the same thing. So if they issue an order, it's like landlord, tenant, small claims court. You can actually go to the court and request the court order it, meaning somebody from the board will have to show up to court and explain why they didn't carry that decision out. So there is accountability. It's just knowing that route, and it's very difficult, and knowing if your specific case qualifies to enforce, to say the board is stepping way out of line here and they're not, the checks and balances that are in place, management supervisors and all that, are just ignoring it. So After that, you would go to an appeal hearing at the WSIB. I've done both written and oral hearing. I'm of mixed view on them myself personally. I find sometimes with injured workers it's very difficult because you're dealing with the mental stress and anxiety of the injury and your injury itself, and you might not be able to get the perfect answer, and sometimes the decision maker will hold that against you. Then you're dealing sometimes with the employer rep who gets to cross-examine you. I'm very protective of my clients knowing this stuff, and I do plead accommodations under the Human Rights Code, oftentimes ignored.
So Pam, when do they generally allow an oral hearing at the appeals resolution branch?
So I can tell you when they don't. So nil decisions, they're not granting you anything. SIEF decisions, usually like if you're on behalf of the employer or the employer rep for second injury and enhancement fund relief, no, they're doing it, you're doing it by written submissions. They go back and forth with psych entitlement because sometimes they'll say, okay, we want to hear testimony, we agree with you. Sometimes they'll say we have enough information in the file. So I honestly think that it comes down to who is being assigned to the file and whether or not they want to do the oral hearing or they're sufficient with the medical. My problem with anything outside of NEL appeals on behalf of a worker is I think that the worker should be able to choose whether or not they want to testify. Because at the end of the day, I have seen over the 21 years I've worked with you, medical information that's in a file that is not accurate because the board is paying somebody to see the injured worker, so they don't include all of the relevant information. I mean, I've had clients call me and say, I'm reading this report from a specialty clinic, and I had a full out conversation about other issues that aren't even in there because the board has denied it. And even though they relayed the information to the doctor just doesn't put it in the report. So I think that if it has to do with physical ongoing issues, psychological ongoing issues, or inability to work because of one or both of those disabilities, that the worker should be able to push and say, I want to testify because I don't think that the written material is sufficient and I want to add additional information.
See,
But that's not what the case is.
and that's one issue that I raise is one is that being allowed to have an oral hearing, and the other issue I have is being able to have witnesses there. Like I asked for the board's doctor to come so then he could explain his report. Like he made this report, and if it was small claims court or the higher court, you make a report as an expert. I have a right to call you and question you on it. Nope, not allowed. Not allowed to call the doctors or anyone. So how can you tell me this is procedurally fair in allowing me not to fully and fairly present my case? So that would be, in my opinion, or is a huge issue on appeal, either at the tribunal or if you have to do judicial reviews, to say they had specifically requested these witnesses were denied. They requested an oral hearing because there's many things that you can't get out. Now, I can see the higher courts go, well, you could have submitted an affidavit from the injured worker, which I've done, where my client was denied an oral hearing. I just do an affidavit. The only problem is if it is contested by the employer, then they would challenge it and say, hey, we weren't able to cross. And I'm like, well, that's not my fault. That's the board's fault. See, that's where I think if it's the issue is was the worker looking for work? Is the worker able to work because of pain, suffering, and these other things? Then that should be the measure in many ways. Not to mention the fact, like you said, is oftentimes doctors are used by the board and are very biased. And it's funny because in the book I was reading, Insurance Bad Faith, that's one of the elements of bad faith is when insurance companies use select doctors. And I mean, that's another topic again, but it's one of the things that you can challenge in the doctor's reports that are done by the board doctors and clinics. Now I'm finding out, Pam, that the board is forcing injured workers to go to their treating doctors and clinics, their specialty clinics, they call them. And when you look at it, there's two issues I have with that. One is the law itself says I get to pick my treating person, but once that's picked, that's it. Well, I would argue that, but so them saying, no, 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 not your doctor, you go to this one. that denies that law. You know what I'm saying?
Hmm.
The other issue is them forcing me to their treating clinics and stuff. That is a charter violation under security of person, right of autonomy, blah 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 blah. So at any rate, you've done your appeal and say the ARO renders their decision, and we talked about time limits, and if they deny your claim or part of it. So you can go to the tribunal appeal even if the decision was partly right, and then they pay benefits and they say, well, we'll pay you benefits for 6 months, but that's it. So you can continue to appeal anyway. It doesn't have to be a completely negative decision. And to do that, you have to appeal. And again, this is another contentious issue within 6 months. The tribunal, I think it's just 6 months. There isn't a limit for return to work or anything. And you have to do it in writing to them. They changed their whole forms. Why, I don't know. Fine. And then they changed their process where you have to do confirmations and all this other stuff. So you do that, make sure you're within the 6 month time limit. Now, oftentimes I've talked to injured workers that are outside that limit, and this is where I take an issue with some reps who are advising them and saying, oh, you're done, you can't appeal. That's not necessarily true. If there are explanations as to why you didn't file it in time, for whatever reason, then you can request an extension of time. And there's been many where it's been granted, especially in cases where there was one client that I represented and the employer misled him as to his right to appeal, deception, and it was granted.
How long would you say is the maximum miss of a time limit?
For the directed, there's two, remember, there's the appeal and reconsideration. Appeal is 6 months.
But how many months late do you think you can be
It
till the
depends
tribunal is
on your
going to tell
issue,
you you're too late?
but it depends on your issue. Like if you're beyond, like if you're 6 months and a day, I think they would let it
Yeah.
without any explanation, but it's hard to say. I mean, I do find the tribunal is generally, and I'm biting my tongue when I say this and grinding my teeth, are generally fairer than the board.
What about 3 years in a day?
The one I had was 7 years.
And they allowed it through?
Yes, and it was actually not an appeal to the tribunal, it was appeal at the board level.
And why did they allow it after such a long miss?
Because of deception on the part of the employer, claiming that the worker didn't have any right to appeal or anything like that. The standard ones is if you weren't able to form the reasonable intent, maybe you have a disability, maybe you're in the hospital or something, right? And then the other one is deception on the other party that misled you as to your rights or something. Um, Generally, like it's rare that that happens, so it's always best to just keep an eye on the time. Again, I don't agree with the time limits at all for obvious reasons. Once you've filed your appeal, the appeal at the tribunal can be in writing or it can be oral, just like the WSIB. I did notice too, though, going back a step about the board and tribunal, both, all their hearings are Zoom. I don't think any are in person now. Eventually, I can actually see them going back to in person again, which I thought Doug Ford said everybody was going back. But regardless, so so just like the board, you have a written appeal or oral appeal, and I think if your issues are very complex, then it'll be an oral appeal. Meaning, when we say oral, it'll probably be by Zoom. I've heard of some by telephone, and I'm like, why tell? You have video at least. So at any rate, once that decision has been issued, which takes anywhere from 8 months, 6 to 8 months or longer. It's not the individual. They're not just going, oh, I'm bored today, so I guess I might. No, 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 no. It's a lack of resources, lack of enough decision makers. That said, so once they issue the decision, it'll be in writing. You'll get it in the mail or by email, whatever. Then if you're like, no, this is seriously wrong, you can do what's called as a reconsideration. I've been successful on a few reconsiderations. As I was saying before to Richard, every step up the appeal process you go becomes harder and harder and harder to get the decision overturned. So be prepared for that reality. A reconsideration, the threshold, I don't like the statement I hear from the tribunal when they say limited resources. I think it's a real slap in the face, and I think they should take that line out because you're dealing with people in most cases that are on the verge of homelessness, or maybe some are. And I think it's a real insult when they put that in there, especially when the board that's funding them has so-called surpluses. That said, I think the basis should be, as the chair says, is, and I don't know if I agree with this or not, other colleagues have talked to said they don't agree with it. A reconsideration, they use the judicial review standard of reasonableness, meaning the decision could be wrong, but they'll leave it. It has to be unreasonable, right? And there's like 20 or 30 well, there's 2 categories and 20 different reasons of what's unreasonable in the decision. And it basically, you'd have to show that they've committed a serious error of law, and in cases of fact that they completely ignored, like a famous case was Fiera, where the panel members completely ignored all the medical evidence because they thought the worker was faking. So they ignored all the medical evidence and denied the claim. It then went to judicial review, and the divisional court said, no, you can't do that. You're not doctors. You can't put your personal opinion in place of medical evidence. And that was a rare case. So if that happened, you can cite that case and then bring that up, and then you might get there's a two-stage process to the test for reconsideration. One is, should they allow the reconsideration? Then is, if they do, should they overturn the decision, meaning what should they overturn? It's you kind of bang your head against the wall saying, isn't it the same thing? Not really. You have to argue why they should open this up. And then secondly, is that what is wrong with the decision? When you're like, well, no, if I argue if the decision is seriously wrong, wouldn't that be the first? Technically, yes, but that's how they do it. The next stage, I've done reconsiderations, and I've done 2, 3, 4 reconsiderations and been successful to some degree in them. Time limit on reconsideration, there is no written law limit. The law says at any time, but the tribunal doesn't put it in policy or law. They put it in their practice, and they say 6 months. Again, I don't agree with it. I think if there's an error in the interest of justice, they should look at it, right? Because many times I've had reps or workers come to me and look at it and go, yeah, your representative really messed you up with this. They should have done this, or they didn't have a representative, or they're suffering from severe disabilities. And they're looking at the watch and going, done.
What about getting a new medical report for reconsideration?
You have to be careful on that, because they say any evidence. There's a weird threshold with this, and the board is all over the place with it with the case law. Again, I take issue with this seriously, because it used to be, if it's medical evidence that's clarifying existing medical evidence, okay, good, they will do it, but not always.
Yeah.
Then is, if the evidence was in existence at the time of the hearing but not available, you have to explain why. I'm like, why? That doesn't make any sense either. Again, you're dealing with 99%, well, 100%, you're dealing with people with disabilities. They may have seen a specialist and then forgot to tell you because they're suffering from depression, and then you discover and go, what the hell? Why didn't you tell me? It's because of their disabilities. This is something, again, not recognized at the tribunal level or the board level, right? So then you can sometimes successfully do reconsiderations, and I looked at the tribunal, the case, the CanLE, the database of them, and they do. But to answer your question, Richard, about new evidence, bringing it in, I would love to say definitely the test is this, and like I've studied Butterworth's, I can rhyme it off because I've memorized it, but they don't go by that. They kind of flip-flop, you know what I mean? And it really, I don't like decisions coming from decision makers. I don't know about you, Richard, where it's what they call discretionary, meaning if I don't like you, this is what it feels like. If I don't like you, then I'll say no. That is very bad law or legal practice. It should be very clear, objective, meaning this, okay, or this, no. You know what I mean? It allows for discrimination, racism, sexism, and that kind of thing. That's my justification of having a well-reasoned, rational decision. And I've yet to see one from the board or tribunal. Now, I noticed the board started copying and pasting policies, which is great. But then it's like, it's very difficult. Like it should be, I've denied your decision, your request, because law, policy, right? So state the law, state the facts, and then your analysis being this, right? And a lot of the times you don't see that. Time with
How
that.
many? I think we have 30 days to go to court to file a judicial review,
Yeah.
which again is extremely short.
Short, yeah. Especially
Yeah.
on how much is involved in actually doing all of the paperwork and stuff like that once you get to that stage.
But
It used to be,
you've got to file the notice that you're seeking the judicial review
right.
within
And
30 days of the decision you're disputing.
Yeah.
it used to be there was no time limit in the law, and the divisional court set a soft 6 month time limit,
So
right?
you've
And
got
then
to,
before it
they'll
changed.
extend it for a few months, but you really need to get going right away. Let
Well,
me
like,
speak to judicial review for a minute.
yeah, go ahead.
So I'd say when we're speaking to prospective clients, I get a call about every 2 or 3 weeks. Somebody wants to go to court after losing at the tribunal. And to take an example, when we did the case saying that the limit on benefits at age 65 was contrary to the Ontario Human Rights Act, we went to court challenging the law. And I might say that the vice chair agreed with us. It was the worker and the employer member who disagreed. So that's why we lost at the tribunal. So we had good support going to court. The problem was if the average case to go to the tribunal takes us 20 hours of work in terms of being at the tribunal, preparing it, getting medical reports as necessary, that's $12,000 risk because most of these cases we do are contingencies. So we've got $12,000 investment in the case. But to go to court, rather than it being 20 hours of work, it's generally like 50 hours of work because the paperwork is humongous. There has to be paperwork outlining all the facts. There has to be paperwork outlining all the law. There has to be research in the law. Preparing for the cases are done live, so you have to actually be there. You may be sitting in the court for hours waiting for your turn to come up. So you're looking at 30 to 50 hours. So the fees, instead of being 12,000 at stake, could be anywhere from 40 to 60,000 at stake. And I tell injured workers, like the chances of winning in court are maybe like 1 in 5. And we at our law firm don't have the resources to start making 1 in 5 bets. So in the case of the age 65, we made the 1 in 5 bet, spent the 50,000 odd dollars doing the case. And the reason, of course, was it was an extremely important case, and we thought we had a very good case. And we lost. And we lost because the court said, well, only 9% of the population is working over the age of 65. So it's quite reasonable not to cut people off at 65. That case is that age
Revisited.
65 issue is going to be relitigated if the government doesn't change the law. But this time we're participating, but the injured workers consultants who are government funded, they're the ones who do most of the paperwork and lead the case.
See,
Uh,
what frustrates me, Richard, in the way you're talking and I'm talking about representing injured workers and them getting help, it's frustrating because there is a government organization 100% funded by the WSIB, meaning no tax dollars at all. And that's the Office of the Worker Advisor. And I'm not blaming the staff again. I want to make this very clear. It's administration, right? That they do not represent injured workers at the court level and they do it at the board or tribunal level. And the injured worker has to wait oftentimes years. In my own personal situation, I was initially represented by the OWA. Then when the board said, okay, yeah, you're injured, they agree. But then, like you said, Pamela, the back and forth games, well, you didn't do self-directed job search and everything. I went back to the OWA and they said, yeah, you'll have to wait. And at that point, that's when the Mike Harris cuts kicked in, and all of a sudden, we'll deal with you right away, went to a 5-year wait. Well, 2-year and then 5-year wait. So it's like, yeah, my landlord's not going to wait 5 years, you know? So then unfortunately you're forced to either do it yourself. I've called lawyers around. They either want five or $10,000 retainer. I can't afford that. I have no money, right? And it's frustrating because, and again, I'm not criticizing refugees or anything. What I'm talking about is the government systems. Refugees in Canada, when they have a case, they can go before, they can do the tribunal, just like injured workers, and then they go to the court to do judicial review in Supreme Court. All that is 100% funded by the government programs for refugees. And I'm puzzled why that isn't happening for injured workers when it's clearly written in law that way. It says to represent injured workers. Now, it doesn't mean the OWA has to represent themselves. They can fund lawyers like legal aid does and pay them privately, and they don't, you know? And I
So
think that's
Paul,
part of the reason.
Paul, we're at the 30-minute mark. So
Yeah,
why don't you give us
I'm done.
your closing view
That
on what we
that's
should think
just
about?
I was just going to close with that point is that's the reason why I think you don't see many big cases in the higher courts, divisional court, court of appeals, Supreme Court of Canada from injured workers is like you said is you have to bear 100% of that legal cost and you can't, you know, and I think that's something that injured workers should be looking at and saying, well, why isn't the OWA following the law in Ontario? Other provinces, I don't know.
All right. Well, thanks everyone for participating. And we'll see you next week with someone who can answer some questions as to what the heck is going on at the board.
Yeah, it's the union president.
Yes, thank you.
That will be
Thank you,
interesting.
guys. Take
Thanks.
care.